Hello everybody, I am doing this video because I've had a couple people ask me to address the issues of the distinctions between common law and civil law, Roman civil law. And also I thought I'd take this time, being that they are differentiated by basically the spirituality of it. So one is spiritual law, which is natural law and common law, and one is law of commerce, that wants to regulate the flesh and things. So I wanted to start off with that because I've had a lot of people with biblical issues, questions, and some wanting some focus as well. So first of all, let me just say that the Bible is full of law. And that, in my opinion, the Mandela effect has not changed the law within the Bible. I have, in my research that I just did today to write this piece, I found nothing of significance changed in the actual biblical law aspect of things. So it might be changing the minutia, the names of like things and such, a penny versus a denarius, a lion versus a wolf, and although some of those have very specific meanings, the greater body of law that within the Bible that our founding fathers used to establish the instruments, the organic instruments of the States of America United, have not changed. At least none of the ones that I researched today, which by far is not all of them that are in there. But I wanted to touch upon some specific ones. So, and I think you've gotten the idea of what this particular piece is. It's people had questions as to whether the founding fathers used Christianity as a foundation for the organic law of the States of America United, and most definitely yes, they did. Because, and now when I first started doing research in law, I had a mentor of mine tell me that we were a Christian nation, or that the tenets of law were Christian. I totally argued with him. But as I've researched law and for the last several years, reading law and learning about law and the Bible, because it's an instrument of laws, along with other philosophers and religious texts, I have learned that the reason why we're a Christian nation is because we brought Christianity into the Constitution. It was the founding principles for the organic instruments of state. And I'm going to go through that and explain to you. So if you're like me going, no, we didn't, yeah, they did. So let me go about and start with this. So what I'm using for my reference is a book. My mother got me a Bible, a book. And it is not the family Bible that we have. I wanted an older version that was more genuine to the. It's called Original Tongues of the instruments itself. So I'm using the Holy Bible containing the Old and New Testaments, translated out of the original tongues, and with the former translations diligently compared and revised. And New York American Bible Society, instituted in the year 1886. So this is that was the oldest one that she could find. So I'll have references directly out of this, and there's 3 times I'm actually going to read out of it directly. So I just wanted to warn those who are listening that do particular things when the reading of the Word comes. So this is all about the reading of the Word. So the Bible, specifically the King James Version of the Bible, is a witness to the trials of an innocent man, Yeshua, which we all, there's a variety of Yeshua. We also know him as Jesus Christ. So if I use those interchangeably, know that I'm talking about the same man. So that this was done, in my opinion, so that we would know the truth through the witness of the apostles, and through them be saved from the lawlessness that it exposed. That it's a testament, and it says, here, for the last 2,000 years you've read this. Do you think he's innocent? Who do you think's guilty? What principalities are exposed, and who was Jesus really fighting? And who did he rail against as an anarchist? Because he was an anarchist. So, and again, if anyone who's religious is hearing this and is offended by my words, just know that I'm a philosopher. I think I've made the disclaimer that I am not, I would not classify myself as a Christian. I do read the Bible just as I do the Constitution, just literally, if it says that a fish had 3 gold coins in its mouth, a fish had 3 gold coins in its mouth, because you have to take them literally in order to interpret the allegory and the metaphor. And the reason why that I got such an old book in the original tongues is I wanted to get as close to as you can get, because it's definitely been adulterated by man. I wanted to get as close to the true meaning of the words, or translation of the words, as I could. So let me start by saying that what I'm saying about particularly the King James Version, being the New Testament, being so the King James Version of the New Testament is the witness of the 12 apostles of the trial of an innocent man by an authoritarian, abusive state, and some inherent systems in the middle there, which is what we're going to discuss. So the fact that this is the witness of this is exposed, or is affirmed in a variety of places in the Bible itself. It's affirmed specifically in the Gospel of John 1:8, where he says, John inferred, was not that light, but was sent to bear witness to that light. He's speaking about being witness to the light of God, in his mind, Jesus Christ. He interchanges those, Father, Son. And it's also affirmed in the Gospel of John 5:33 through 34. And 5:33 says, Ye sent unto John, and he bare witness unto the truth. And the Gospel of John says 5:34, But I received no testimony from man, but these things I say, that ye might be saved. So he's writing it from recollection, okay, of what he knew. So he's not talking about other people's testimony, he's talking about his in that particular. And each gospel, when you read it in the New Testament, the Gospel of Matthew, he literally is telling you the same story that the Gospel of John tells you. These are just them telling you the witness that they give of what happened to Yeshua in his trials and tribulations with the Romans, the Roman Empire, and the Pharisees and his fellow men. So the other, and I'm going to talk about some major concepts of common law and things that I've brought up in previous videos, such as that we have a nomenon within us, that the founding fathers believed that we had a knowledge of what was right and wrong within us. And that is, and even though Kant does talk about it around the same time and writes about it as a philosopher, it's affirmed in the Bible itself. In the first epistle of John 5, it says, If we receive the witness of men, the witness of God is greater, for this is the witness of God which he hath testified of his Son. So he talks about the nomenon and the higher law. So at first he says, we're going to discuss that the higher law is the natural law, and that it comes from within us. So again, in the first epistle of John 5:9, he talks about the higher law, and that it's the highest law. The natural law, or the law of God, is the highest law, and that natural law and common law is the highest law, pursuant to the Constitution, and it's affirmed in man law statutes, as all laws must comply with natural common law affirmed in the founding organic documents of the American Republic and the state. It did create. So we have a nomina that we are born with, and our founding fathers created an instrument of organic common law, and it's really a divine instrument in their intent, in that they felt that it was an extension. It was like a proclamation of men of the cumulative knowledge of the Christian faith and other faiths, because they were of a variety of other faiths. Not everyone was Christian. But they took the tenets of Christianity to form the instruments of the common law. And they didn't do it. They brought those instruments from Europe. Some of those instruments that already existed as far as the instruments of common law. So in affirming the existence of the nomenon, we talk about the first epistle of John 2:27, and he says, But the anointing which ye has received in him abideth in you, and ye need not that any man teach you, but as the same anointing teacheth you of all things, and truth, and is no lie, and even as it hath taught you, ye shall abide to him. So that right there is an affirmation in the Bible that you already know what is in you, that you don't need another man to teach you what right and wrong is. It's in you. And so the inference is that you don't need a state to educate you or tell you what laws are for, because we have our own laws within us. That that the purpose of state is not to tell you what's right and wrong. The purpose of state is to affect what we, as its founding fathers and mothers, believe a society should be structured as. It's supposed to be an assistance to the structures of society. It's not supposed to define society or control society, because you do that in your law. So also in the Bible, the concept that, remember I spoke before, if you've watched any of my previous videos, that St. John talks about lawlessness being a sin, and so that the law existed before the sin, and specifically in the first epistle of John 3:4. If you were to read any portion of the Bible just to see if what I'm talking about is true, that there's law in the Bible, read the first epistle of John. It's got tons of law. It's got a lot of really good, important stuff there about spirituality in it as well. Very, very, very spiritual piece that he wrote. So it also, again, the concept of sin being a crime, and that sin is the crime, that there's the law and the lawlessness is sin, so sin is the crime, the breaking of the law. So in the first epistle of John 3:4, he states, "Whoever cometh, sin transgresseth also the law, for sin is a transgression of law." So that's in the Bible. Law is a sin. Breaking the law is a sin. And a sin is not just, and you know, because God put knowledge of right and wrong in you, you know it's a sin. So, there you have it. You're not supposed to break the laws. You know what they are. You're born knowing what they are. And so the other aspect of the common law is that the sovereign man has the control, and or woman, and or child, beast, like I said earlier, sometimes, in some people's minds, that the act of one is what makes an instrument de jure versus de facto. A de facto instrument can be made de jure by the acts of a righteous man, and a de jure instrument can be made de facto by an unrighteous man. So it's the power and the control and the free will of the one to follow the law that defines every aspect of the law. The one is the powerful instrument, the singular man or woman. So that's affirmed in Romans 5:18 through 19, where 5:18 he says, "Therefore, as by the offense of one judgment came upon me to condemnation, even so by the righteousness of one the free gift upon all men unto justification of life." So, and he goes on to say, 5:19, "For as by one man's disobedience men were made sinners, so by the obedience of one shall many be made righteous." And this is an argument, for, to use it in a practical purpose. Cops can't get mad about people thinking that they're all thuggerts and criminals, because there's thuggerts and criminals within you, within your union, and you haven't cleaned it up. It seems like you don't want to clean it up. It seems like you support the fellow men and women you have that, because women do too, violate the substantial rights of others. So in the Bible, in the common law sense, the actions of one man affect what the whole of that organization that man belongs to. And that's an understandable concept. It's guilt by association kind of thing. So when someone who is being lawlessness is exhibiting behavior, and you as a union do nothing about it and don't affirm your outrage when it clearly is against the law, or is there a question that you don't know that it's against the law? And that's even a bigger issue, because the state told you could do it, that you think that's law. That's not the way the law works. Just because the state says you can do something doesn't mean it's lawful. That is a fact of law. So, if you are out there and you see things and you know in your heart that something's wrong and that it shouldn't be done, you're supposed to stop it or not do it. And if you're part of a union of men, when men like that or women come forward like that, you are supposed to want them out. That you're supposed to go, I don't want them to represent me. So that's a very significant aspect of the law. So let's talk about natural law versus man law. And natural law is, or common law is God law, as it's the law we are all born knowing in our hearts as the nomenon, as Immanuel Kant would say. It's the highest law governing all, even the state. So it applies to all, even the state, equally in all situations and all circumstances. Now, this is a concept of Aristotle. I didn't make this up. So Aristotle speaks to the two types of law, and one is natural law, and then I'll get to the second one in a minute. But they said this would be the law of the United States of America. So, or the States of America United, as I like to say for clarification. It's the law of the Spirit, okay, which is derived from our Creator as affirmed in the Bible, and the common law derived thereof, and in the instruments of the States of America United in the Constitution and such, with its Articles of Amendment, that and the aspects of the Judiciary Act of 1878, all those instruments that founded this republic are in the minds of the founding fathers and mothers, and me personally too, as part of that lineage of the people who helped found this nation, that I believe that it is an organic instrument of spiritual natural law, and that it's divine. So then we get to the second type of law that Aristotle talks about, and so that this tells you, if Aristotle is talking about these two kinds of law, that they've existed for since Roman times, since Egyptian times probably too, considering some of the sigils and stuff that they share. So particular law is man-made law, as statutes, codes, rules, ordinances, orders, and opinions of state agents, which are applied unequally to particular situations, to particular men and women in particular situations. So they're called. So then you have. So basically, the man law is the particular law, and the God law, the natural law, is the law of axioms and maxims. And so this would be the law as statutes of like the United States Corporation, the man law, which governs the flesh and things under Roman civil law, and the Uniform Commercial Code, such as contracts. So there are some aspects of God law that are in contracts, but you can disagree between two people to set aside the God law if you want. If you're, free, white, and 18 is a phrase I was taught, from my hippie parents. So you can contract to do something unlawful. People do it every day. So two consenting people of reasoned age are allowed to make contracts that can be in contradistinction to the natural law. So that's why we have the two types of law. And unfortunately, we're just in one side of law. So I want you to understand that. So the law, the natural law, is not about things and flesh. It's about principles. Of what is righteous and good versus evil and dark, and the abuses of powers of state making war upon the people. That's really what the higher law is for. Because again, Aristotle will tell you, when you are faced with an argument of particulars that you disagree with, the only thing you can do to win, even potentially even win the argument, is not to argue the particulars, because you're never going to win in particulars if a case is brought up against you, to be honest with you, because they'll change the particulars. That's what they do. So if you have an argument in particulars that's being oppressed upon you, the only thing you can do is revert back to the higher law, the natural law, and that's what Aristotle tells you to do. And again, these are all concepts that existed in the Roman state. I don't know about the natural law. Theirs was monarchical law. But they definitely had the Roman law and the particular laws, which is actually why there was a Peloponnesian War. But that's a different story. That's a whole different video. So, law is not about things and flesh. And this is affirmed in Ephesians 6:12. It says, "For we wrestle not against flesh and blood, but against principalities, against powers, against the rulers of darkness of this world, against spiritual wickedness in high places." And it's also affirmed in the Epistle of John 1:5-9, where it says this. I believe actually 1:5-8. I'm sorry. Starts 1:5. "God is light, and in him is not darkness at all. If we say that we have fellowship with him and walk in darkness, we lie and do not the truth. But if we walk in the light as he is in the light, we have fellowship one with another. If we say we have no sin, we deceive ourselves, and the truth is not in us. So another aspect of the common law is that man is flawed, because the Bible tells you so, that we are full of potential sin and malfeasance because we have this great gift called free will. So in the applications of law, be it the natural law or particularly the particular laws, we're supposed to assume that we could be wrong when we judge others. And this maxim is established, this not judging people harshly or excessively, as you may someday be found to be wrong in your judgment yourself, because you're flawed and not perfect. And there's always the possibility that how you judge something could be wrong and an error for lack of knowledge or for a variety of things. But this is affirmed in the maxim sedant arma togae, which means let the sword yield to the law. Let the law of power, war, yield to the reason, the law of reason, which is law. Law being a philosophy that's founded on reason and logic and mindfulness, those things. So wherefore, inasmuch as all judgments of the flesh are founded in sin, all judgments in the flesh are subject to appeal. And thus appeal because everyone could potentially be wrong, because we have malfeasance in us and sin. And thus those who do presume to judge others with the law of power of the state instead of reason are not in law, but are effecting feats of war upon the people. Now this is actually affirmed, this particular construct of sedant arma toga, and judges operating in contradistinction from the bench and being tyranny from the bench is actually affirmed in a very famous case law called Penhallow versus Doan Administrators, and that's 3 U.S. 54 in 1795. It is that you can find that on the net and in Nexus Lexis, I believe. So again, I'll probably put a reference to that in the comment section for this video. So again, we're full of malfeasance. Even when we judge people using the higher law, we are still subject to appeal to other higher bodies of natural common law. So the other aspect of the common law that was brought forth and put into the instruments of the Constitution, I believe, is that all of humanity is an instrument of God. And when operating in the law, under the will of God, using the nomenon that God gave us all. And it has to be, though, not for personal gains, not for lucre, not for greed, graft, or avarice. It's literally just for the principles and the bodies of law. And that is actually what the petite juries and the grand juries of the common law are supposed to be looking at. They can also look at particulars, but they're supposed to use the guidance of the higher laws. They're supposed to ensure that all of those higher laws are being fulfilled. And thereby we are an instrument of the divine law of God as we affect them through our internal spirit and knowing and nomenon. So it's really this wonderful philosophical foundation for a very spiritually guided society, where even commercial constructs are moral and follow the tenets of the common law, that all men are equal by their Creator, and they have these unalienable rights to contract and protections of due process. So it's a wonderful foundation for a moral society. And that's, in my opinion, personally, why I believe that the Constitution for the States of America United and its amendments thereof is an incredible organic philosophy law document that brings forth in the hands of man a divine spirit of equity, that all men can live peaceably without totalitarian instruments of state and be kind to each other and good. It's just a wonderful document when you read it in its context with the biblical philosophy that came with it and the other religious philosophies that came with it. Like I said, it's not just full of, these tenets are affirmed in other religions. Okay, so it's not just Christian tenets, but you will see that some of the founding instruments and organizations of the common law, as they are supposed to be affected, are completely established by instruments within the Bible. And the first one of that, but let's talk about the instrument of all of humanity being an instrument of God. This is affirmed in the Gospel of John, again, 5:30, and where he says, I can of my own self do nothing. As I hear, I judge, and my judgment is just, because I see not my own will, but the will of the Father which hath sent me. So in his mind, he was sent here by God to be righteous and to be an instrument of God. And the only distinction really between the apostles and the average man is they just choose to walk in the light all the time. That they're just divine spirits because they follow the law, the tenets of the law, and what was given to them in the nomenon. So now the next point is very important because whereas most of you don't understand that we are all deemed legally dead by the instruments of the civil law. We are all civilly dead instruments. Okay, we're considered civilly dead. We are considered dead, lost beyond the sea. Now that's a term of law, beyond the sea, that is used to declare an entire nation, a country, a civilization. At this point in time, I mean, a man could let me kind of expand on the concept of beyond the sea. It was a term that was brought after the New World, or in shipping. A man would have a claim in Brussels, and he would get on a boat and go somewhere, and he wouldn't come back for years. And so if he had a claim against him, they couldn't find him, they'd say he was lost beyond the sea, meaning outside of our jurisdiction. Not only outside of our jurisdiction, we don't even know where he's at. But we can still, claims can be made against his estate and stuff like that when he's beyond the sea. So we're lost beyond the sea. So it's a term, lost beyond the sea, and it's used in our particular circumstances to declare an entire nation, county, civilization civilly dead when it goes into rebellion. So against the prevailing authority, the legal civil Roman authority. Well, this was done. When this is done, all lands, inclusive of our flesh, our bodies, in our particular circumstance, our bodies, okay? And as I said, the Constitution applies to the whole world. So they're like, hey, we're just going to call y'all, it's all your bodies are civilly dead. So it's inclusive of the flesh when it's made of land, which ours is made of land. And they are declared dead beyond the sea as claims against the estate and chattels, etc. So of the man, claims of the man and the woman cannot be affected in some situations. The resolution or a bankruptcy can't be settled in a claim beyond the sea, because you can't dissolve a man's entire properties without his consent, and he has a right to due process, you know. So I could go into the statute of limitations, which used to be forever, and how they were changed right before the Federal Reserve Act and the declared bankruptcy of the nations of the world, which it was. The statutes of limitation for claims beyond the sea were changed, I believe, to 7 years. But that's just another video, again, altogether, which I may get into at some time. But know that the concepts of dead beyond the sea and them being changed in England, and then right after they were changed in England, they passed it 7 years later, they passed the Federal Reserve Act. So I don't believe that that's coincidental at all. So regardless of that, the whole of the people in the world, when they're declared dead beyond the sea, all of that gets put into a trust, a land trust. Okay, so when the British subjects rebelled in 1666, and when we went into rebellion during the American Civil War, we, the people, were all declared beyond the sea. Okay, and civilly dead by the head of the central bank, the Pope at the time, and all of our holdings, our biblical jubilee, were put into trust, sestake the trust. And that's a term that a lot of law people are familiar with, but it's a type of trust, okay? And the agents of Rome were sent, the attorneys, the temple bar, were sent to abrogate, or they were already here and had helped with the coup in our case. They took over the abrogation, subrogation, hypothecation of our debts and bankruptcy. Now, mind you, the 13th Amendment prevented them from doing that. So that's why they had to obfuscate the 13th Amendment, because the Pope wanted all the land. He wanted all the land in trust as the central banker, head central banker, because the Rothschilds worked for Rome. They worked for the Pope. When the Suffragette Act of 1666 was effected in London, from what I understand, what I have read, the king abdicated and a Rothschild administrator was put in the kingship, in the seat of the monarchy. So anytime that there's a Sestake trust established, those people thereafter are administrators for the Holy Roman See to effect bankruptcies. So this also occurred, okay, when Yeshua was crucified. But I'll discuss that later. But there was a trust established when they crucified Yeshua. And as such, when they speak of the dead, and the point of this, the significant point of the fact that we are declared dead beyond the sea, is the point of this is pursuant to, this is my belief, and for me it makes complete sense, and I think that you'll be able to follow this, in the fact that we are dead beyond the sea. When the Bible talks about speaking of the dead and their resurrection, I believe that that's just a metaphor for all of us to be declared, having been declared dead, wherefore we are now resurrecting. We're in resurrection now because people are starting to be learned in the law of spirits again, and are asserting that they aren't dead, that they are living flesh, living in the spirit as the salt of the earth. And the concepts of living in the flesh and the spirit and the salt of the earth is affirmed in the Gospel of John in 5:28 through 29, where it says, "Marvel not at this, for the hour is coming in the which all that are in graves shall hear his voice." Well, they're talking about the dead hearing God's word. So in 5:29, and they shall come forth, that they have done good unto the resurrection of the light, and they that have done bad unto the resurrection of damnation. So when you come back to life, you're going to be judged. The judgment will be had. And so I can tell you that when you realize that you're supposed to be, when you wake up and you realize you're supposed to be following a higher law, you're going to go, oh, I shouldn't have done that. And you'll judge yourself a lot. There's a lot of self-judgment reflection going on in a lot of people right now, hopefully. That's part of the awakening. That's part of the reveal. And that's part of the resurrection, to walk in the Spirit. So it's also affirmed in Romans 8:1 through 12. And I'm going to read that because it's a little longer. So Romans 8 through 12. The title in this book, and that is, Who Are Free from Condemnation. So, chapter 8 of Romans 1 through 12. Wherein is therefore now to condemnation to them which are in Christ Jesus, who walk not after the flesh, but after the Spirit. For the law of the Spirit of life in Christ Jesus hath made me free from the law of the sin and death. For what the law could not do, in that it was weak through the flesh, God sending his own Son in the likeness of sinful flesh, and for sin condemned sin in the flesh, that the righteousness of the law might be fulfilled in us, who walk not after the flesh, but after the Spirit. For they that are after the flesh do mind the things of the flesh, but they that are after the Spirit, the things of the Spirit. For the carnally minded is death, but to be spiritually minded is life and peace. Because the carnal mind is enmity against God, for it is not subject to the law of God, neither indeed can be. So in that particular, in summary for some of us, a little more to read. But it's basically saying that the law of God is not the law of the flesh. The law of God is the law of spirit. So our founding fathers, in bringing the concept of natural law and common law into the instruments of our state, say that it's the law of God. It's not the law of flesh. Flesh being the law that men put up, trying to justify themselves in actions that they do that usually are, they're trying to argue particulars to the God law. Well, it doesn't really mean that, does it? Well, yeah, that's what the God law says. Again, just like you shall not lien a person's right to defend themselves and carry a gun. The Second Amendment shall not be a lien. What part of thou shalt not a lien? You know, it's like one of those questions. But the man law wants to parse the particularities of the natural law, because that's what they like to do. And there are reasons for that. We'll go into that. But I wanted to kind of summarize that section before I went a little further. So, because the carnal mind, I'll read that last section again. Because the carnal mind is enmity against God, for it is not subject to the law of God, neither indeed can it be. So then they are in the flesh, cannot be God. But ye are not in the flesh, but in the Spirit, if so be that the Spirit of God dwell in you. Now if any man have not the Spirit of Christ, he is none of his. And if Christ be in you, the body is dead because of sin, but the Spirit is life because of righteousness. But if the Spirit of him that raised up Jesus from the dead dwell in you, be that raised in Christ from the dead, shall also quicken your mortal bodies by his Spirit that dwelleth in you. Therefore, brethren, we are debtors not to flesh, to live after the flesh. So I'm sitting there talking to you about how we've been declared dead beyond the sea. And then the concept of being dead beyond the sea, we are having bankruptcies and estates abrogated through trusts. Because they can't take all of our holdings, they have to abrogate it through bankruptcies. And I think that last section really speaks to that therefore, brethren, we are debtors not to the flesh, to live after the flesh. So it specifically speaks to being deemed dead in the flesh, but alive in spirit, and being debtors, okay, but not to the flesh. So that's why they can't solve settlements. They can't ever prove in law that you're a debtor because you're not in the flesh. So that's a very important aspect. That's why I wanted to read that. Okay, let's go on to the next section. So the natural common law governs the principles of the flesh and things, not the flesh and things themselves. Okay, it's higher. It's above that. It's above the flesh and things. And this is affirmed in the first epistle of John, again, at 2:15. Love not the world, neither the things that are in the world. This emphasis, in the world. If any man love the world, the love of the Father is not in him. Now, this is a very powerful statement. That basically, if you are, and this is the concepts of trapped in the flesh. Jesus says, do not be trapped in the flesh. That is a principle, guiding principle of Christian tenets, that you should not be trapped in the carnal concept of flesh. And then it goes on. So thus those that argue, so in saying that, what they're saying is that those that argue or revel in flesh and blood and things are not in the natural common law. They are in man law. So if people are sitting arguing particulars, they're not arguing God law. They're arguing man law, trying to argue an aspect of flesh to see if they're within God law. That's what they're supposed to be doing, not making up statutes that are in total opposition to God law and saying, well, this is the high law now. No, it's not. It's supposed to be held to the higher law. And again, I talk about how the concept of the common law being vacant of the institutions and the grand juries and stuff is not doing that cycle where man makes a statute that's in particulars. And then we're supposed to argue whether those particulars are satisfied and are following the greater good, the common law, the natural law of things. So that we can actually parse in our flesh some type of spiritual divinity. And that's really how it's supposed to work. It's a beautiful construct and a beautiful instrument when we learn to do this, which I think we're going to learn in very short order, to be honest with you. So now let's talk about the concept of trespasses versus torts, remedy versus relief, and complaints versus claims, because it's important to understand these so that when the language comes up in the Bible texts, and they do come up, that you'll understand the difference between the two. And being that trespasses are being things by which money or material compensation can bring relief, versus torts or tortures. That's a really easy way to do it. A trespass versus a torture, which money and material compensation cannot remedy. Okay, and then a trespass is relief. And they're brought forth by complaints, and they are settled by monetary or material awards to cover losses. And they can have compensation and punitive and all those things associated with it. And then you have tortures, and they are brought forth and deemed remedy. So you have trespass and tortures, remedies and relief. And then they are brought forth in claims. So then you have trespasses, torts, reliefs, remedies, complaints, claims. And in tortures and remedy relief, there has to be a real victim, because you can't torture a corporation, okay? You can't tort a corporation. You can tort the flesh. And so you have to have a real victim with physical, emotional, spiritual, character, monetary damages. And so again, so you have trespasses and torts, relief and remedy, complaints, claims, monetary, material compensation that doesn't necessarily need a real victim. It could be a thing, a corporation, versus something that has to have a real victim. And if, depending upon if there's malice and forethought in those things involved, or intent to harm, accidental torture is different. But an intent to torture, that brings about criminality, where people can be put in prison or kept from society. Really, shunning is really about the only thing that we're abided by law to do, is to shun, is to not allow them to be within society. Excuse me, I want to take a drink. Okay, now let's get to the big body of how the Christian tenets are within the instruments of the common law, the American common law system. Because some of these things are specific to American common law, I believe, that I found. The first one is the requirements of petite jury, which is a jury of 12. Now, in the natural common law, a lawful petite jury is a body of 12 of your peers selected directly by you from your community. Your judge, Elohim, are members of your neighborhood. Little e Elohim, not big E, little e. Little judges, because the word Elohim is a judge or an administrator. So your judges, your Elohims, are your neighbors, your neighborhood. And the number of the petite jury is found in the number of apostles and disciples chosen by Yeshua. And it affirms that you're to choose them and that it's to be 12 in the Bible and within common law. And that is affirmed, and that's how they became apostles, as he chose them. And that is affirmed in the Gospel of John, again, 15:16. And it says, ye have not chosen me, I have chosen you and ordained you. So Jesus chose his apostles and ordained them. And when you choose your jury, you're ordaining them to be your little man Elohim, their little judge. And it's also affirmed in the Gospel of John 6:7, where he says, have I not chosen you 12? So the concepts of a petite jury being chosen by you from your community, who you ordain to be your judge, are completely founded in the constructs of the 12 apostles and Jesus choosing his 12. At least that is my belief. I don't have any other constructs of how it could be any differently derived thereof. Because 12 is not an odd number. It's an even number. And particularly when you take votes, they like to have an odd number so that there can't be a draw. There can't be 6 of one and 6 of the other on the question. So I believe that 12 comes from the Bible. So in Luke 6:12, he says, he called his disciples to him and chose 12 of them, who he also designated apostles. And it goes on to say that they were vexed of unclean spirit, and they were healed by Jesus in this respect. Wherefore your jury must be clean of spirit and not tainted or prejudiced by unclean spirits or influence. So when you choose your jury, you go through the process because you need to make sure they're not prejudicial to the construct. They have to come clean. They have to come with open hearts and just their nomenon. They can't be prejudicial, have already decided and made a decision against what is being judged and what their duty is to judge, what they've been ordained to judge. So in contrast to the legal petite jury, which is a body of 12 that one is made to select from an already selected pool. You don't select it. The pool is already selected for you of people provided by the state. So the state, who is the plaintiff in almost all cases, that we speak of or that we have issues with, unless it's an independent action civil case. But in municipal cases, criminal cases, the state is always the plaintiff. And they pull those from state voter registrations and driver's license rolls, usually. It's not just random. You just have to be engaged in one of those things. You have to be licensed by the state in some way, shape, or form, or agree to be a voter. And you're in the county that you're registered in, who by elections or actions have agreed by getting a driver's license and by agreeing to be a voting United States citizen, you agree to be under and surrender to the jurisdiction of the state authority and thus you're already prejudicial to the principles of the state who's filed the complaint, because you're like, well, the state brought it, and I don't mind the state. I'm part of the state. And so the only problem with that is that in the legal petit jury, if you're challenging the jurisdiction or the authority of the state to bring the action against you, such as in a demurrer, which even in the legal man-made law, a statute, you have the substantial right to demur, to challenge the jurisdiction, as you have the free will and have the substantial right to choose whom you call your governance and with whom you contract. So how are those who have agreed to be in the state jurisdiction, which you yourself are challenging, are they able to be untainted as a jury of your peers? Because again, the court has to prove personal jurisdiction. And as I spoke of, for example, in municipal corporations, they don't give you the option, which is strictly unconstitutional. They automatically make you part of that jurisdiction. So that is an issue in the legal sense, that you are in forced jurisdictions, okay? So the other language that is distinct is a distinction with attorneys at law, is they like to twist these two terms. There's a trial by a jury of your peers, so a trial by a jury of your peers, and that is the lawful trial of your petit 12 jurors, which you choose, and that's described in the organic constitution, who judge you by the law held therein. But then there's the jury trial. That is a legal trial where a magistrate or a magi, a magician, is your judge, your little Elohim, that judges you by legal man law, as statutes, code, rules, ordinances, and whatever legal man law order or opinion that the magi wants to make up at that day. Because remember, he's a particular law, and he can apply particular things, particular situations, so he can make up particulars all he wants all day and judge you with particulars. And say, well, I know that you saw the guy before me get 6 months, but I'm going to give you 2 years. I know it seems like it's the same guy, but the difference is maybe you're black and he's white. Because you're black in particular, or even white in particular, just pick one, I'm going to change how I apply the law to you particularly, because I have a particular issue with your particulars. So it's all about just parsing till they can get to you and argue you into a corner, okay? And he does that, so he can make up law, he can make up statutes, he can ordain things from the bench. And they do that all the time. They're not supposed to, but they do. And that's because he believes that he is a false god of state. That I've actually had a judge say to me, I'm the law. And I was like, really? That's not what I read, the Constitution or any statute. And I've had a prosecutor say, I'm the state of Ohio. I mean, really? So I'm the guy across from me is the state of Ohio, and the guy on the bench, who's also a state of Ohio agent, says I'm the law. So how is it that, and then the jury is chosen by, I don't know if they got together. I mean, what are the rules for that? There aren't. There's questions of even sometimes of where they even get these people. Do they see the same people all day? Do they pull them out of the back? There's never a time where they're actually to disclose these things that happen, how the jury is selected out of a pool, how they're sent. And and there's no checks and balances to determine whether or not even their own administrative rules are being followed. Because again, the judge can just make up, say, go get everybody out of the back room back there. Just go next door and grab the state employees from the probation parole department. There really is nothing in my mind that precludes them from doing such particular actions. Because it's made up law. They make it up as they go along for whatever purpose they want to get by. Because at this point in time, there are zero checks and balances. There are zero checks and balances in the system. Your entire system is completely cooed by the same union, and they all collude and conspire to just statutize stuff, as I've said, for the purposes of bonds. So, let's talk about the requirements of the grand jury of 24. Now, in the natural common law, the lawful de jure common law grand jury is a body of 12 lawfully elected from the freeholders of the county by general election by lawful ballot, not poll, ballot. They must live and be vested materially in the county. There's some particulars in the old ideologies, or the old constructs of it, as far as being a freeholder, allodial titles, and stuff like that. We're not going to get into that. I'm talking about the basics and how they would apply in the restoration of the Republic, okay? So, They have to be materially vested in the county, but are not required to agree to be under any jurisdiction other than the natural common law. And the reason why they have to be materially vested is because what better person to judge you than someone who lives there and has to live with you every day, and you're bringing an argument saying, well, I don't think this is unlawful because this affects how I handle my cows. If you are also a cow holder, that you're all dairy farmers, invested in the thing, you're going to listen very intently to the argument that your neighbor has against whatever law has been brought forth that he's being charged for, and he's arguing against. Because you are a cow farmer too, and you are going to judge him by what way you would be judged. You would want to be judged yourself. So one of those phrases, judge not lest thee be judged. Well, that means if you're going to judge that guy, you better be willing to take that judgment upon yourself. So again, that's why they're supposed to be materially vested in the region and the county, in the local control of the county. So So you're not required to surrender to some authoritarian jurisdiction. You're just supposed to be in the law. It's about the law, the principal bodies of law. So the due process rights of the defendant and the accused are preserved and protected, and the defendant the accused is required to attend and is allowed to have counsel and bring forth material facts upon the record, bring forth testimony and witness in defense of self. And effectively, it's a pretrial where the plaintiff must bring material facts upon the record, affirming their averments of trespasses or torts, where they go, hey, Bob did something to me, it harmed my cow or it harmed my farm or whatever, and you have to prove that he damaged you and that his rights stopped where your rights started, those types of things. And that's what the grand jury's for, is the plaintiff, it has to bring forth his claim. And there's not a presumption of guilt. There's no guilt. If the plaintiff fails to present a case, the grand jury is not going to bring forth an indictment or a true bill. Okay, and that's an important part that I'll parse later too when we talk about the distinction in the grand juries in the legal aspect. So upon an affirmation of the plaintiff's complaint, they'll bring forth, upon the affirmation of the plaintiff's complaints and claims, the jury bring forth a true bill under penalty of perjury by the law of the jurisdiction, common law, or if there are statutes being applied. But the jury is just supposed to look at the statutes and make sure that they're being applied in the greater law. Okay, so again, and they're going to be subject to these statutes, that they're running through the process of the greater law. So it's going to apply to them when they're done with this case, if they're in the same plight as him, in the same neighborhood. So they'll, and they have to bring it, under penalty of perjury by the law of the jurisdiction, affirming their positive averments of the plaintiff's averments. So, and the name of the elected jurors and the record of the proceedings are required to be placed upon the record of the cause of bar. One, the jurors are elected, so you know who they are. And then the proceedings are of the public record. And I believe that the number of the grand juries that we use in our construct comes from Revelations. In that Revelations, they talk of 24 elders. And the concept of Revelations is mentioned 5 times, elders is mentioned 5 times in Revelations. It's in 4:4, 4:10, 5:8, 11:16, and 19:4, 19:4. So again, that's 4:4, 4:10, 5:8, 11:16, 19:4. Wherefore the 24 elders with white robes, with crowns of gold, hold prayers of saints and worship the God of the Bible. Now, people with crowns of gold are not slaves. So, and they would technically be sovereigns if they have crowns, they would be a little less sovereigns. If they hold that much gold and they were of the American construct, they would be freeholders of the land. So they would be deemed men of knowledge and wealth, who have an understanding of the natural law and don't need the state to live and operate because they're enlightened enough to do it all for themselves. And often the state needs them to fund things, to pay for roads. A lesser person with less money would need to go to a sovereign with a crown of gold to bond an action, to bring forth those 20 silver pieces in suits of common law. So again, the 24 members in a grand jury, I believe, are from the 24 elders in Revelations. And then it goes about to say in 19:4, and the 24 elders and the 4 beasts fall down and worship God. And then it goes back into 19:2 where it says, for truth and righteousness are his judgments, for he hath judged the great whore, which did corrupt the earth with her fornication, and hath avenged the blood of his servants on her hands. Now, I personally believe that the 4 beasts of Revelations are the 4 ends of the court to the holy temple, which would then mean that you have the 4 beasts being the 4 ends of the court to the unholy temple becoming holy. Okay, and then a grand jury of 24 sat by the tenets of the common law, bringing forth some claim against the whore of Babylon. So that's my interpretation. I think it fits with me in what I believe the process for the correction of our government. Those processes would correct all the corruptions of the world governance that we have right now. If the if the 24 jurors came and brought forth a common law indictment against the merchandising of men, the Babylonian slave structure, the corrupted instruments of commerce that are running us, and in order to do that, we'd have to have the 4 ends of the court of the temple to start operating in the law, and not just running amok with statutes. So if we had all that, if they did all that, if we could do all that, we would have utopia on earth, because we would get rid of the constructs that plague us in malfeasance right now. So now let's compare that to a legal grand jury, where the jury is selected and appointed by a state agent or judge, just like they're selected out of the pool. And they're either selected by the judge or plaintiffs. I don't know. Ask an attorney. Ask them, how do they select those people, back there? They tell you how they select them, but again, no one's checking to make sure they're doing it, okay? And so they selected from the purported pool of those that they have agreed by voter registration, driver license to surrender to the jurisdiction of the state. And in these are some very particular distinctions, okay? So in the legal grand jury, the due process rights of the defendant and the accused are totally suspended. They are allowed, if they are allowed to attend, which rarely they are in criminal cases because they're in jail. So they have these ex parte. The defendant doesn't show up, and they are not allowed to active assistance of counsel. So if they are brought before the grand jury, they don't get to have a counsel, again, suspended due process rights. Their counsel can't talk. They can't have active counsel help them, okay? And if they even want to talk to them, apparently they have to walk outside of the room. They can't even have open counsel in front of the grand jury, which seems very odd. And they cannot bring forth testimony or witness in defense of self. So you're like, okay, I'm going to go before a whole bunch of people where I can't talk, I can't bring witness, if I've even brought before him. And this guy who's going to bring his people that have agreed to be in his jurisdiction, where he's a state agent, are going to bring forth all this testimony against me, and I can't say anything. I can't do anything. Due process totally suspended. So, and the true bill is not brought. The true bill, if it's brought forth, which it almost always is, I'm going to tell you that right now, except against cops, strangely enough. So the true bill is not brought forth under penalty, or other state agents, people who, like Hillary Clinton, if they had their type of grand jury, she would just be exonerated. So a true bill is not brought forth under penalty of perjury by any law, or law as statute of the jurisdiction, affirming their assessments of the plaintiff's presentments, whereby this presentment or true bill itself creates a variety of bonds. So as soon as they bring the true bill, boom, you can make all these bonds. You're going to bond the action, right? So a legal grand jury is basically a secret ex parte hearing, witch hunt, where anyone can be easily affirmed to have charges brought against them, again, for purposes of creating bonds. By way of bonds for the complaints itself, warrants, arrests, bail, all that stuff. There's a variety of bonds that are made every time they bring forth a charge and an indictment. So a lot of money is made Okay, there are numerous cases brought forth in recent years where the grand jury never even existed, and the true bill was just created by the prosecutors out of thin air fraudulently, and the foreman's signature was forged. They actually, I do know that they have cases, or there are cases pending where that is actually the case. And these grand juries are almost always held in secret, ex parte, with the manner in which they are generally selected never required to be placed upon the record, nor the names of the purported jurors are rarely required to be placed upon the record, nor the record of the proceedings, the actual conversations, the things presented by the plaintiff are not always required to be put upon the record. And even though they may be subpoenaed, I mean, again, because the judge has to agree to make them do it, and they kind of protect their own. So they don't always make those available, even though they're subpoenaed. They kind of do what they want, to be honest with you. So the defendant, again, his due process rights are suspended. Okay, if he wanted to challenge the proceedings and see if anything was done unlawfully, good luck getting a hold of the evidence or the proof to try to prove that. And again, the foundations of the legal grand jury, they can pretty much do whatever they want. So it's not really beneficial to even challenge these, okay? So the legal grand jury is basically a secret witch hunt where anyone can be easily affirmed to have charges brought against them by the suspension of due process. Again, for the purposes of creating bonds by way of bonding the complaint, bonding warrants, the arrests, the bail, all that stuff. So again, it's all a big racketeering scheme to create bonds, because your due process rights should not be suspended if someone is going to charge you with a crime or complaint. In fact, the Constitution makes it so they're not supposed to. Due process is never supposed to be suspended. Okay, so let's go now through the steps to bring a claim in law, common law, natural law, and compare that to biblical things as well. So in natural law, an actual physical victim is required with a complaint of loss or claim of harm. So a bond must be proffered by the plaintiff to bring the claim. The victim actually has to, unless she can, get someone else to proffer the bond, you have to proffer the bond to bring the claim. Or you can take it to the grand jury for presentment for criminal, but you still have to cover your claim, whatever you're claiming. And the minimum would be 20 silver pieces as established by the Constitution. So both things and flesh can be sued and sue for relief. However, these fictions in law cannot bring criminal claims against the flesh by the maxim which gives that whatever is afforded to the plaintiff must be able to afford it to the defendant. So, and such a fiction law can't be put in jail or prison, and a de jure grand jury can bring such a suit and remedy. So if they can't bring you, a corporation cannot bring a suit in remedy and claim criminality. It can claim relief, trespass, where the resolution is a monetary thing, because the corporation can only be trespassed. A corporation cannot be tortured. And in the common law, only men can bring charges of remedy, of tortures, where there's a criminal intent involved. And so if a thing is damaged, the thing must go to the grand jury. And the men and women in that grand jury must agree that the man violated the people improper, that his actions against the thing damaged the people, the state. And so this is where they say, oh, well, we're working through that when we took this to a grand jury, except they're not following grand jury common law tenets. And they're also they're doing a variety of things that are not constitutional and don't comply with common law. But that's a different system, and that's the point. But still, that system is supposed to comply with the greater, higher law. So things cannot sue men in criminality. So how is it that the state of Ohio can bring forth claims against you in criminality? Well, things can sue things in criminality, And again, remember, you're dead beyond the sea. You are a legal fiction, okay? You are not deemed a flesh and blood man. You are deemed a thing, a civilly dead, beyond the sea thing. And since you're a thing with the state of Ohio, that's a thing, they can charge you with criminally. And then they hold your flesh as surety, okay? So this concept of and additionally, fictions in law have no special exemption from protections. You know, corporations can be bankrupted by just criminal acts because they can create criminality in civil law. And the way you do that is you take their assets. You leverage damages against them and claims of equity. And you take every bit of money they have. And so there's no protections for corporations from being completely bankrupted by criminal actions. That the concept of too big to fail of a bank does not exist in the common law, because if a bank is that corrupt and it's not going to fail, what it would become owned by the people. It would become a public bank, because clearly in its private capacity with private board members and private owners and all this other stuff, you guys operate in criminality. So guess what? We're going to take it from you and give it to the people. And they're going to take it by claiming all your assets in claims of equity for frauds. So there's no protections for or exemptions for things in the common law. And they do not like that at all. They do not like that, because they love their state. And they want to make sure their municipal corporations and their states, which are always exempt most times from prosecution, particularly criminally, and have limitations put on how much money you can get from them. The jurisprudence has said you can't sue them out of existence. Well, in the common law you can. Okay, that's a fact. So these are affirmed in Matthew 28, 15 through 17, where it goes, "Moreover, if thy brother," and this tells you how to bring forth a claim. This is what we're going to learn here. So this is how you bring a claim in the common law, and that's biblically established. "So moreover, if thy brother shall trespass against thee, go and tell him his faults between thee and him alone. If he shall hear thee, thou hast gained thy brother." Okay? So, secondly it says, "But he will not hear thee. If he will not hear thee, then take with thee one or two more, that in the mouth of two or three witnesses every word may be established." So witnesses of two or three are required to establish facts of law in the common law. "And if he shall neglect to hear them, tell it unto the church. But if he neglect to hear the church, let him be unto thee as a heathen man and publican." Now, so basically, you talk to the dude that created the trespass or the tort first and said, you know, you really harmed me. We should settle this. And if they're like, I didn't do anything to you, then you go back with your witnesses and you say, hey, you did this, and I demand that you pay me, or that you go to jail, or that you do something. And if they go, I don't care what you say, then you go take it to the church, which at the time the church was the highest level of state in this respect, in the biblical sense. So the state in this case is quite the church, and in that they are the higher authority, so you're supposed to take it to the state. Well, if they ignore the state, and then they are, actually in this case, in our law it's the state. In this case it was the church. And it says that if he is a heathen man and a publican. Now, the interesting word publican, this is important, because a publican is the class designated by the word in the New Testament who were employed as collectors of the Roman revenue. The Roman Senate farmed the direct taxes and the portions, the customs, to capitalists who undertook to pay a given sum unto the treasury, the publican. So they subcontracted out the lands to capitalists and asked them to repay them with a tithe for allowing them to use the land for such thing. And so they received the name publican, because the treasury is the publican. So basically, Matthew 28, 17 is basically saying that a man who ignores God law and the church is a man who is one who believes in the treasury of men, the money of men. So the contracts of this kind fell naturally into the hands of the equites, the elites of the richest class of Romans. The elites of the richest classes of Romans, and where they appointed managers, under whom were the the prior orders, and actual custom house officers who examined each bale of goods. So they created a system of administration. So they allowed the lands to be used, but they also put in a system of checks and balances and put their employees in charge of seeing what goods you made off their lands. And they counted the bales, okay, as in Baal worship. Okay, so they counted the bales of goods exported or imported, assessed its value more or less arbitrarily, and then they would write out a ticket and enforce payment. So bill of lading, you value it, write out a ticket, here it's valued, and then they were required, as a portion of that, to pay taxes into the treasury for the use of the land and the amount of bales of whatever that they made. So Baal worship is a paying of a tithe to the treasury in this respect. So essentially, a publican is a citizen under Roman jurisdiction who worships man law as statutes, commercial law, and the treasury, as well as its taxes, commerce, and Baal. So anybody who's a religious person knows that Baal is a demon, and that he's the demon pertaining to the workings of commerce upon the land. And it's also, Baal in this respect is a tithe that one would pay. And inasmuch, but still, it's supposed to be in our system governed by the natural and common law. But inasmuch as they don't have to listen anymore, not even the church, in my opinion, because they don't, in their opinion, that person would be biblically a reprobate, and they would be damned to go to hell. If all they care about is commerce and Baal and tithe and treasury and money and things, then again, remember, they're outside the law. So that's why it's a very important distinction there, that the term reprobate. So if a person, if you go to them and you say they damaged you the first time, and you're supposed to do it privately the first time, and they ignore you, then the second time you're supposed to take witness. You're supposed to do it publicly, and they still ignore you. Then you take it to the church, which would be, in our construct, the common law grand jury. If they ignore those things, then they're just reprobate, and that's pretty much the belief as it's established biblically. So in legal man law, the distinction of a lot of things pursuant to how you bring forth a claim and who can bring forth a claim. For example, in man law, you don't need to have an actual physical victim required to bring a claim, or loss or claim or harm, criminality. They don't have to. There's most crimes, most people in prison are victimless crimes. Drug addicts are victimless crimes. And you can even go check that out if you know anybody who's ever been in prison or are in prison for a drug crime, even if it's intent to manufacture. It'll say no victim on their felony page. It'll say no victim, because there really is no victim. I mean, they were operating freely in commerce, and the people who came to them surely knew that they were not agents of state authorized or licensed. I think they probably do. Now, the problem is, people associated with overdosing and such like that, but it's free commerce. So that's why there's no victim, because the only victim would be you didn't pay taxes to the state. You didn't pay your bail, okay? So there's no bond. There's no bond is proffered by the plaintiff. Usually the corporate state brings the complaint or claim. So the distinction, the state never has to pay a bond. In fact, if I were to explain it to you, you actually pay your own bond. You proffer your own bond to sue yourself with your susdicate. They go and attach your susdicate, and they pay a bond or initiate a bond with your money and your susdicate that you can't even get to bring the action against you, the civil claim. It's very messed up, the paradox that they have us in, okay? So, though the state, things can sue and bring claims and charges against the flesh, so the state itself is not subject to claims, usually, and thus cannot be charged criminally as a state. Corporate legal fiction, a fiction law, cannot, even though it can't be put in jail, it can put you in jail in the legal. And it's actually given special protections and exemptions from civil claims. So it's just like this amorphous thing that you can never touch that doesn't have to proffer bonds. So there's no incentive. In fact, they're incentivized because it doesn't cost them anything to bring as many claims as they want to just produce bonds out the wazoo, So it's completely different than the common law, what we're running under right now. And that clearly tells you that you're clearly cooed, because the instruments of law were founded in the Constitution were founded in biblical law, and they're clearly not conforming with there being a higher law that they're supposed to apply to it. And in fact, it even says if all they're doing is collecting bail, excuse me, then they're clearly in the flesh, and the Bible tells you if you're in the flesh, you're not with God, which means you're not in natural law. Okay, so now let's talk about witness requirements. I know this is a very long video, but these are all very important points, so I'll probably split them up. And if I don't, then just bear with me and watch it in sections, because these are all very important aspects to understanding the common law and how we're not in it, and how it's founded in biblical law and why it's considered the higher law, ordained law, natural law. Okay. So witness requirements, we're going to compare these now. So on common law, witness requirements to establish facts in law require 2 or more witnesses in concurrence, giving testimony under penalty of perjury by the law of the jurisdiction that they're in. Okay, and that is affirmed in Matthew 18 through 20, where he says, "Verily I say unto you, whoever ye shall bind on earth shall be bound in heaven, and let me read that again. Whosoever we shall bind on earth shall be bound in heaven, and whosoever ye shall loose on earth shall be loosened in heaven." Okay, again and again I say unto you, that if 2 of you agree on earth as touching anything that they shall ask, it shall be done for them of my Father which is in heaven. For where 2 or 3 are gathered together in my name, there am I in the midst of them. Okay, so basically saying that when 2 or more people of righteous intent bring forth or sitting there witnessing, it's as if God is witnessing it. As I said, we are instruments of God. That's what biblically this is affirming. And there's also also it's telling you that you need 2 or more people to witness things if you're going to bring forth things in the law. You can't just bring forth one unless you do this. Okay, for example, God as your second witness in natural common law. And that's affirmed in the Gospel of John 5:31-32. So the Gospel of John 5:31, it says, "If I bear witness of myself, my witness is not true." 32 says, "There is another that beareth witness of me, and I know the witness which be witness of me is true," inferring God as a witness. So this is important if something were to happen and you had no witnesses. You could say, "I swear before my God that this is what happened." So that's one of the times, but it has to be something that you are personally saying you witnessed. Okay, so it's also this extends this 2-person before God. Extends to all contracts, inclusive of marriage, which is a contract, and oaths, in that one does not need a legal notary supported by man law in order to affirm contract of oath. There's no one. You only need to invoke the witness of God. So if there's 2 of you, and you have God with you because you're operating in law, in contract, which you freely have the right to do, you don't need a legal notary. You can affirm your presentment, your treaties, whatever you're going to do, as long as you invoke God as your witness. And that's between the 2 of you and God. And so that is a tenet of law that is specific to the common law. Okay, and the fact that the God can be your witness and that you don't need to invoke the state is affirmed in Matthew 19:6. It says, "Whereof there are no more twain, but one flesh. What therefore God hath joined, let no man put asunder." Now they use this in marriage a lot. Basically, if 2 people join themselves before God, there's nobody that can break that contract. It is an undisputed contract. No court, no jury, no judge, no nothing. If you 2 agree in private contract to certain conditions, it's nobody's business to challenge your treaty. Now, if one of you brings suit, they'll say, "Hey, did you follow the tenets of that agreement?" But they can't come in and attack your agreement and your contract and tear you apart. So that is affirmed. Okay. So in contradistinction, a legal witness requirement to establish facts at law, as statutes require no second witness, no invocation of God, no oath under penalty of perjury by the law of the jurisdiction when giving testimony against one for trespasses and torts. So, and this is an example of this. I'll give the specifics. This pursuant to Ohio Rules of Evidence 801. It says, a witness's testimony is considered not to be hearsay, but credible and testimony of fact if one is testifying in a trial, though that witness is not required under oath. So they're saying basically you just have to be in a trial and giving testimony. You don't even have to be under oath under penalty of perjury by the laws of any statutes. Nor are their statements required to be affirmed by a second witness for them to be deemed as fact. Juries are told all you have to do is hear one guy say something, not under penalty of perjury, and you're supposed to accept that as fact. That's how they convict a lot of people with what is it? Some guy in a jail cell says, yeah, he made a comment to me, and when we were in prison, and I swear that he said that, he did this crime and this, that, and the other thing, and he comes to the jury, and he's a one-person witness, not under penalty of perjury, and he never has to prove by a second witness that you said that. Now that is called parole evidence. And parole evidence, and it's a little bit of a sidebar, but parole evidence is secret evidence that no one can prove you said or you didn't, and it can be used specifically in claims of equity. So that should tell you that they're trying to affect claims of equity against you, and you don't even know it, because they allow parole evidence all the time. That's when you go talk to your parole officer in pre-sentencing, you are actually giving them parole evidence to use against you. That's why it's called a parole officer. You're a parolee in belligerence, and you're going to go talk to them to give parole evidence that they can use against you for claims in equity. Nice. It's quite a lot of attorneying going on here. So let's so now let's talk about that. This is 100% this capacity to have one witness who doesn't have to have a second witness to affirm facts. That's totally in contradiction to the national common law. And that is actually affirmed in Deuteronomy 19:15, where it says, one witness shall not rise up against a man for any iniquity or for any sin, in any sin that he sinneth. At the mouth of two witnesses or the mouth of three witnesses shall the matter be established. So it even says in the Bible that under the common law, under the natural law, one witness does not a sin make, does not a crime make. You have to have two or three. That's in the Bible. That's the law in the Bible. And they're not following that, folks. They're not following the tenets of the common law that are affirmed in this country as they were established under the Christian tenets in the Bible, affirmed in the Constitution, and the amendments therein, conferred therein. So, just that fact alone, that they think by their own rules of evidence that all a person has to do is come to a trial and not put their hand upon the Bible or not affirm that they're giving testimony under penalty of perjury, and that one person can convict you or bring a fact against you and say that you've committed a crime that doesn't have to be affirmed by anybody else. And that one person could be a cop or an investigator or, just an agent of state. So you got the agent of state, the prosecutor charging you. You've got the agent who says he's the state. Okay. Then you've got the judge who says he's the law, and he's an agent of state. Then you have a guy who can come as one guy and not be under penalty of perjury as a cop. And by the way, when a cop is in his uniform, he's allowed to lie, even on the stand. That's why they don't make them say it's under penalty of perjury. In fact, if you bring up the aspect, like for example, when I had a trial that I was in, I had my witnesses affirm that they were giving testimony under penalty of perjury, and the administrator had that stricken off the record because he didn't want that to be there, because if I did it for my people, then the plaintiff would have to do it for his people, and they can't do that because then they can't lie. Okay, and when people go to court and they go, that guy lied on the bench, he lied the whole time. Yeah, they do, they lie. They lie and collude and corrupt to create bonds. So it literally is racketeering. And I'm going to tell you, from my opinion, it's racketeering the preponderance of the time. Not like rarely, like it's rarely lawful. Like rarely is there actually a circumstance in these legal courts, forums, temple courts, where they have pews, Pharisees in the robes, do they actually comply with any aspects of the law? They make things up as they go. They are allowed to lie. They are allowed to bring one witness and convict you with the fact. And it could all be, and then if they don't get you on that, then the administrator will just make up some rule that create law from the bench to make sure that he can get you in the particulars in the particular way he wants. Now, these abuses of statutes in particular law was, again, exactly what caused the Peloponnesian War, where the regional parts of Rome were being administrated, and they were having their bail, and they were allowing them to use the land, and the civil authority was taking tithe and this and that. And then they were bringing forth these claims under statutes with particular laws, and they were finding that, if you were a citizen of Rome, you might get one privy. If you weren't a citizen of Rome, you wouldn't get a privy. If you were this color, or just this day versus the next day. If they wanted your money, they'd bankrupt you. And that it's a corrupt system is what it is, if it doesn't have the common law checks and balances. There's nothing wrong with the system over here if there is the checks and balances of the common law, which affirm that the statutory process is following the greater, higher law. That is not happening, folks. It's totally running amok, and they're doing whatever they want to do. That is just a fact. In my case, I got told that my pleading was too long because I named as many failures of the law, process, or execution that I could, and it was like 161 pages handwritten from prison. Okay, and I had something like 89 errors at law or fact, and that was me without a computer able to read. And they told me I had to pare it down. It was too many, But the point of me doing that was to show that they're just pretending. It's a pretend process. It's not the real law. It's a simulation of process. That's why it's at law versus in law. So these biblical references that people like to argue that our law isn't founded on actually prove to you what they're not doing, and the fact that you are not in the common law. So that's why I think it's important to do this to the extent that I am doing it, so that you all can understand, hopefully. Now, in the Bible, the term restitution and trespass. So these are other examples of laws in the Bible, and that's in Numbers 5:7. It says, "Thee that shall confess their sin which they have done, and he shall recompense his trespass with the principal thereof, and add unto it 1/5 part thereof, and give it unto him against whom he has trespassed." So if you plead guilty, you're supposed to pay that plus 1/5. And Yeshua was actually arraigned in the Bible, and that's one of the things that they show, and that's in the Gospel of John 1 through 20, or excuse me, John 19 1 through 22, where Yeshua is represented in his arraignment as a king or a sovereign to the Jews. So I'm going to read that. That's a longer section, and that is, again, this is in the Gospel of John 19 1 through 22. And the title of this one actually says Christ arraigned and crucified. Okay? Take a drink real quick. The Bible is a wonderful instrument to read for law, and I'm lucky that even though I was raised Roman Catholic, I can read it in what I believe that it was intended to be, and don't get stuck in the mumbo jumbo and my religion's better than you. I read the law in it, and it's very clear to me because I walk in the light and I know what's in me. So then Pilate therefore took Jesus and scourged him. And the soldiers platted a crown of thorns and put it in his hand, and they put unto him a purple robe. And said, Hail, King of the Jews! And they smote him with their hands. Pilate therefore went forth again, and saith unto unto them, Behold, I bring him forth to you, that ye may know that I find no fault in him. So he represents him as a king. Before, they found no fault in him, so they had to go represent him as a king, because the Jews wanted him tried as king of the Jews. So he dresses him, he represents him, much like attorneys represent you. No, they don't. They represent you as a thing. They take the man and represent you as a thing, just like they did here with Jesus. They've made him a king, which is a seat. Okay. Though he wasn't the king of the Jews. He never said he was. They said he was. So, then came Jesus forth, wearing the crown of thorns and the purple robe. And Pilate said unto them, Behold the man as a king, the man in the seat. When the chief priests thereof and officers saw him, they cried, saying, Crucify him, because he looked like a king now. They made him look like the Jews wanted him to look, that wanted him crucified. So they took him back and made him look like a king and stuck him back out. Pilate saith unto them, Take ye him, and crucify him, for I find no fault in him. So Pontius says, I'm not going to crucify him, you crucify him. He didn't do anything to me, he's your criminal. And the Jews answered him, We have a law, and by our law he ought to die, because he made himself the Son of God. Okay. When Pilate thereof heard that saying, he was the more afraid. And Pilate was smart. He knew to be afraid at this point in time. He's being hustled. He's being used by the Jews to fulfill prophecy. When Pilate thereof heard the saying, he saw he was more afraid, and went again unto the judgment hall, and saith unto Jesus, Whence art thou? Where'd you come from? But Jesus gave no answer. Then said Pilate unto him, Speakest thou not unto me? Knowest thou not that I have power to crucify thee and have power to release thee? Aren't you afraid of me? I'm a judge. I can judge you, dude. Jesus answered, Thou couldst have no power at all against me, except it were given thee from above. Therefore he that delivered me unto thee hath the greater sin. So he's saying, if I'm supposed to be here, I'm supposed to be here because my Creator, this is my path. You have no power. And from there on, Pilate sought to release him. Because he's like, yeah. And basically when he said, you have no power, he said, you don't have jurisdiction over me. My jurisdiction is the kingdom of heaven, dude. You don't have it over me. My jurisdiction is the kingdom of heaven. And when he said that, Pontius Pilate realized that he was saying, demure, you have no personal jurisdiction over me. Mine is the kingdom of God, not your kingdom. And that's why he chose to release him at that time. Okay? So he sought to release him, but the Jews cried out, saying, If thou let this man go, thou art not Caesar's friend. Whosoever maketh himself a king speaketh against Caesar. Okay? And you remember, one of the commands is, have no other gods before me. So here, the Jews are putting a god before God, Caesar, putting Caesar before the God. Okay? When Pilate therefore heard that saying, he brought Jesus forth and sat down in judgment seat in a place that is called the pavement, but in the Hebrew, Gabbatha. And it was the preparation of the Passover, and about the 6th hour, and he saith unto the Jews, Behold your king. And they cried out, Away with him, crucify him. Pilate saith unto them, Shall I crucify your king? The chief priests answered, We have no king but Caesar. So again, the Jews say that their Elohim is Caesar. Then delivered to him thereunto them to be crucified, and they took Jesus and led him away. So, I'm going to go a little further because there's an important line down here. But they cried out, Away with him, crucify him. Pilate said, Unto them shall I crucify your king? The chief priests answered, We have no king but Caesar. Then delivered him thereof unto them to the crucified. And they took Jesus and led him away. And he, bearing his cross, went forth unto a place called the place of the skull, which is called in the Hebrew Golgotha. where they crucified him, and 2 others with him on either side, one, the Jesus in the midst. And Pilate wrote a title. He gave him a title when he declared him, when he crucified him. And the writing was, King of Nazareth, the King of the Jews. This title then read many of the Jews, for the place where Jesus was crucified was nigh to the city, and it was written in Hebrew and Greek and Latin. Then said the chief priestess of the Jews to Pilate, Write now, the King of the Jews, but that he said, I am King of the Jews. Pilate answered, What I have written, I have written. So the Jews wanted Pilate to say that Jesus admitted to being the King of the Jews, when the fact is he didn't admit to being King of the Jews. What had happened is Pontius Pilate presented him to the Jews and said, Does this guy look like your king? He has a crown of thorns and a fake robe, and we beat him, and he's bloody. He's been whipped with a cat of 9 tails, and he's tortured. Is this your king? And they still said, He says he's our king. He's declared himself our king. Jesus never declared himself the King of the Jews. The Jews professed that he had said that and had no proof and didn't bring testimony under penalty of perjury. They just professed it. And Jesus said he didn't. And not only that, he said, Hey, Pontius, you don't have jurisdiction over me. My jurisdiction is the kingdom of heaven. And Pontius Pilate actually agreed with that. And at first he wasn't going to do anything. So this is an important aspect of the representment, because this is exactly what attorneys do for you in the civil law that you're in now, is they represent you as a thing and satisfy the claim of banking, the bankruptcy. So that's a very important aspect, in my opinion. It makes sense to me. I hope it brings some light to you in that. So now let's get this is some really interesting parts, because no one would ever think that these are actually in the Bible. But in having read the Bible and studying the law, it stands out very clearly to me. Let's talk about how the parts of a pleading and a writ are actually discussed in the Bible. And that's affirmed in Corinthians 14-9. And now here's the statement. It says, Now, brethren, if I come unto you speaking with tongues, what shall I profit you, except I shall speak to you either by revelation, or by knowledge, or by prophesying, or by doctrine? Now, 4 things they mention, right? Revelations. Well, in the legal writ, and even the law writ, that's presentment. That's the revelation. There's a crime. The knowledge would be the statement of facts. The prophecy would be the propositions in law, and the memorandums in support. So the prophecy is your argument, how this particular claim violates the law or did this or that. So your propositions in law is your prophecy of how this violates the law. And then the doctrine, and that would be the table of authorities. That would be the underlying tenets and maxims that have been established by previous case law and positive law and juries and stuff like that, if in compliance with the common law. There's a lot of case law that is completely defunct and null, because it doesn't comply with the common law. And in fact, there's some belief that the judiciary actually groomed cases to bring forth bad case law in order to help their coup. So those are in the 4 parts of a writ that you are required to bring forth. Presentment, statements of facts, propositions, law, and tables of authority are affirmed in the Bible in the fact that you're going to speak or be spoken to by revelation, knowledge, prophecy, and doctrine. Now, the fact that you are required to have an oath by affidavit under penalty of perjury by the laws of the jurisdiction at the end of a pleading, a writ, or an instrument of law is also affirmed in the Bible. That is in Hebrews 6:16-17, where it says, 6:16, For men verily swear by the greater, and an oath for confirmation is to them an end of all strife. Meaning, I'm done with my argument. QED. End of strife. I've given you my presentment, my statement of facts, my proposition of law, and my tables of authority. And in the law, I've given you my revelation as a brethren that's being prophesied to. I give you my revelation. Here's my knowledge. Here's my prophecy, and this is a doctrine that I'm bringing forth. And I bring it. Boom! I'm done. I give you an oath. I am done with the end of that strife. It's also affirmed in 6:17, wherein God, willing more abundantly to show unto the heirs of promise the immutability of his counsel, confirm it to be by oath. So again, even if you are in counsel, your counsel is supposed to affirm under penalty of perjury that what they're saying is the truth, that she, if you are counsel, again, promise the immutability of counsel, confirm it by an oath. Okay? So that's an important thing to note too. So it's important to note that when it comes to oaths, again, we're going to talk about how there's a clear distinction between two types of laws we have here. Pursuant to Title 28, subsection 1746, there are two types of oaths that apply to this land. Okay, one is executed without the United States corporation. Thus, it's in law, which is under the laws of the United States of America. Or as I like to say, for clarity, the States of America United. The other is within the United States, the corporate United States, its territories, possessions, and Commonwealth. And they actually parse it out. They say penalty and perjury by the laws of the United States of America versus penalty and perjury by the United States, its territories, possessions, and Commonwealth. So, therefore, again, the statutes in Title 28, subsection 1746 are telling you that there are two types of law as federal in the federal statute. So there are two distinct forms of law and two distinct forms of jurisdictions, and that are in effect in and on the land, depending upon which one you invoke by oath. So the oath defines your jurisdiction, because again, when you do the affirmation under penalty of perjury, you're doing it by the laws of the jurisdiction you're invoking. So depending upon how you answer your pleading or what you put at the end of your pleading defines whether or not you're within the United States, corporate United States, or you're without the corporate United States and in the United States of America Republic, the law. So one declaration would be in UCC, civil law, and under things and flesh, where you're a civilly dead, beyond the sea entity, and you are treated as a thing in abrogation, and represented by a bar union attorney that is a foreign instrument. And in the other one, you are in the common law. So if you don't do these oaths right, you invoke the wrong jurisdiction, your claim's dead. You've confused the bar. You're not clear where you're at. You could come from the wrong side of the bar. So these are all important distinctions that have to be established and are established in the law, in that the oath defines the jurisdiction. Okay? So that's the importance of those differences. Again, that's Title 28, subsection 1746. I have not checked to see if that's even available online anymore. They like to hide sections that expose stuff, and you have to buy really expensive books or go to the library, do a lot of education and look for them, because with statutes you have to start and then move backwards. But they obfuscate statutes that are important as well, and then they underwrite them and move them. I found them where they've moved them 4 or 5 times and amended them and then nullified that and moved it over here. I mean, it's total contrived manipulation and obfuscation of process. So, and it's done intentionally, and there's absolutely no way that they could move stuff around like they do and hide stuff like they do without the intent to defraud. It really is, it's a horrible thing that they do, and I don't even know how they live with themselves, but that's neither here nor there. The right to remedy and relief upon presentment under oath. This is a right in the Constitution, okay, that we are afforded a constitutional right to remedy and relief. That's an obligation of the Constitution. It's a grant, a substantial right of the Constitution. That's affirmed in Hebrews 6:19. And it says in here, but by two immutable things in which it was impossible for God to lie, we might have a strong consolation, who have fled for refuge to lay hold upon the hope set before us. Meaning that we would hope that both by oath of counsel and oath of jurisdiction, that we are able to afford and find remedy and relief within that jurisdiction and by the counsels that we choose. And wherefore, pursuant to biblical teachings, also a vow is considered a pleading. and a votive, an offering of a bond. These are things that theologians discuss and that you can find on the net. So a vow and a votive are also a pleading and a bond. And that would be an example of a marriage, because marriage used to be done by vow, right? Well, there's also a marriage bond where you would bond your wealth. Basically, let's say a man had no money and the woman was the landholder, which is often the case. Sometimes the males had it. But when you married your wife, the father might ask that you provide a bond. And he would ask you to provide a bond in case something happened to you and you died. He wanted to make sure that his daughter had enough wealth to sustain the farm. So you would put up basically a life insurance policy, which is kind of what a marriage bond is. So that would be a votive. So the vow was coupled with a votive. So the marriage bond, or the marriage, was coupled with a bond, a surety in case the husband failed in his fiduciary responsibilities or died. So that then we come to the natural law and the maxims and tenets of default in the common law. And this is a really important section, and I'm getting to the end of this, and I know that I've had your attention if you've even made it this far, which I hope you have. This is a very important aspect of the law, okay? And this is affirmed in the first epistle of John 1 through 17. Okay, the standards for default. And they use this against you. You get first notice, second notice for bills all the time. Okay. So in the first epistle of John 1:17, it says, "For the law was given to Moses, but the grace and truth came by Jesus Christ." So the law of Moses was the first notice of law to the lawless, reprobate sinners. Okay. The grace and the truth of Yeshua was the second notice in the law, though it was given with grace, because that's what the second notice is I'm going to give you the grace of thinking you didn't get the first one. I'm going to give you the second notice. And so he was the second notice to the lawless reprobates. And because he allowed them a second notice, they got a little bit of reprieve. They've had 2,000 years. Okay, well, in the law, the third notice is the default. And that's the last notice in law. Once you go through the first notice, the second notice, the third notice is default. And there are rules for time frames and stuff like that, but that is how the law works, because silence is consent. So if I send you a notice and you don't answer, you kind of defaulted. So I send you the second notice, and I tell you the law and the charges and all that stuff, which I did in the first one. I'm reaffirming and say, hey, this is the second time I'm telling you. Remember, you went the first time and talked to him, your brother, and you gave him that first notice. And you went to the second time. This time you're going to give witness, because the second letter is the witness. That's first notice is one witness. The second letter is the second witness. Get it? So that's your second witness. You went back. So then the third time you go back, you're done. Okay, you're defaulted. Now I can take it to the state or the church, because you've proven that by the silence as consent that you agreed that you committed these crimes and you owe me. Now, there are some rules again for default. That's another video, because you have to profess certain amounts of damages in these things. But it's affirmed that Moses gave us the law and Jesus gave us the grace. Now, we got to default them, right? Because that's what I've done. That's what I've done. I've defaulted these people. Okay, and we're going to go back to the fact that the death of Jesus created a sesticate trust. Okay. And it does bear witness that a sesticate trust was created from the crucifixion, or the nailing to the tree of Jesus, which is what they often do. And that's affirmed in the Gospel of St. Matthew, and that is in 27, 1 through 10. So Matthew 27, 1 through 10. And the beginning of this, 1 through 10, says, Christ delivered to Pilate. Okay. Says, when the morning was come, all the chief priests and elders of the people took counsel against Jesus to put him to death. And when they had bound him, they led him away and delivered him to Pontius Pilate the governor. Then Judas, which had betrayed him, when he saw that he was condemned, repented himself, and brought again the 30 pieces of silver to the chief priestess and elders, saying, I have sinned in that I have betrayed the innocent blood. Because he knew he was innocent. And he also didn't know that they were going to crucify him. And in fact, some people believe that Jesus asked him to turn him in, but that's a different story. And they said, "What is that to us? See thou to that." That's your problem, not ours. Each page is 30 silver pieces. Blood's on you. You're the guy that brought him to us. Remember, Jesus even said that, right? He said, it's not you, it's the man who brought you. So it would be the Praetorian, the Roman guard, Jews, and Jews. Okay? And he cast down the pieces of silver in the temple and departed and went and hanged himself. So he threw his money back at them. And the chief priestess took the silver pieces and said, "It is not lawful for to put them into the treasury, because it is the price of blood." And they took counsel and bought with them the potter's field to bury strangers in. Wherefore the field is called the field of blood unto this day. Then was fulfilled that which was spoken by Jeremy the prophet, saying, "And they took the 30 pieces of silver, the price of him that was valued, whom they of the children of Israel did value, and gave him for the potter's field as Lord appointed him." Now, there's a couple things in there that are important in the law. There's a maximum law that you should never value yourself, that only slaves would put a value to their worth. Because how could you ever say that I'm worth $1 million? Tomorrow you might find the cure to something and be worth more. The man, being ever evolving, can never be valued. So what the Bible is telling you there, that the Jews that, or the Jews that were looking for him, the Pharisees, who said, "Judas, go bring Jesus to us, and we will pay you 30 silver pieces." That established the value of the man, Jesus, for his flesh, his bounty. And Judas satisfied that. So they valued Yehoshua, which pursuant to common law, which means they considered him a slave, okay? Because they put a value to the man. And then they knowingly crucified an innocent man. And when Judas tried to return the fee, the finder's fee, for Jesus, they couldn't take the money back, so they created a trust, a susticate trust, because after the crucifixion of Christ is when the rebellion of the Christians, the followers of Jesus, the way, the truth, and the light began. So the crucifixion of Christ created a rebellion and created a trust from the 30 silver pieces, which became a land trust. So if that sounds familiar with what we're talking about, how the susticate trust creates a trust of all your assets and all the things made of land and all the things, and that's even why they hide patents, because you don't even get to benefit from your intellectual property. They can, but you can't. So that's a very important aspect in there, in that it tells you that a 2,000-year-old trust has existed that the Pharisees established. And I assure you that the Holy Roman See manages that trust. And that there's, remember, since it's in fraud, and they said it was the blood of innocents, they admit in the Bible that they clamored for the crucifixion of Jesus Christ, though he was innocent. They admit that when Judas tried to return the silver. So that means that the crucifixion of Christ was a crime, and it was a murder of an innocent man. And the bonds that were created, the trust, the 30 silver pieces, the land, can be claimed. And that 2,000 years of wrongs can be claimed too. So the reason why I'm telling you all this is because I have defaulted the Jesuits. And I did so by sending a notice to the Real Flesh and Blood Man in the Holy Roman See, who in that see, the Pope, so the Holy See of Rome, the Pope, proclaimed that the previous Pope proclaimed that he was the vicar of Christ. So he's the settler of all debts of Christ. But Christ has no debts. He has nothing. In fact, he's owed a lot of money because they killed him, and he was an innocent man. And there's a bond that's been collecting 2,000 years of interest. plus compensatory, plus punitive. So, the Holy Roman See is the master of the temple bar and the four ends of the court to the unholy temple. And I can prove that they have merchandise, land, men, women, children, and beasts. And the Bible said that the trust was established by the merchandising of men. So you have a trust that was established by the merchandising men. And now they're merchandising men and bonding you all the time. And providing not real wealth, because slaves don't get to play with gold; they get to play with IOUs and paper. So they're not even operating; they're operating in offsets and adjustments, waiting for they're trying to bankrupt your trust. But they're never; it's never going to happen because we're the promise, and we have the property in our minds to exceed whatever claims they could ever bring against us, because they don't make anything. They live off us. They eat off us. They need our flesh to make bonds. They create nothing from just nothing. What they do is they create nothing from something that's yours, that was never theirs. And then they get you to pay a tithe for what they created. Okay? So I have defaulted the Jesuits, and I've informed the Holy Roman See that I am defaulting them, that Moses gave them the law, that Jesus gave them the grace, and they're still doing the same thing 2,000 years later that they allowed the Jews to do last time. Okay? They're still allowing the Pharisees to merchandise men for the benefit of Rome, for Baal, for tithe. And they're still persecuting and torturing and crucifying innocent people and using that money and set aside trust, hoping that one day they'll just steal it all up and they can have the whole of the world that they've set aside in trust. And I'm going to tell you that because I've done this, my life is subject to the whims of lawless people, and I've been informed, I am a hot commodity, and that they are monitoring my every heartbeat, is what I've been told. But having said that, know that I'm not suicidal. In fact, I am morally opposed to suicide. I am in excellent health despite what the lawless ones have done and impressed upon me physically in my incarcerations and my multiple beatings that I've taken, where I've broken bones and things like that. I almost died. And I live a quiet and cautious life. And I've submitted to a vow of poverty. And I have provided an oath. I have submitted my oath to the organic laws of the States of America United, and they're on the public record. So I don't operate in lucre or greed or graft or avarice. I don't do any of that stuff. I do everything I do as the executor Suntory, and I actually pay for all the claims myself outright. And when I help people, and when they ask me for counsel and we contracted counsel, I do it freely. I am free. I actually pay for their charges because I pick and choose, or am asked to speak to people, and I see their significance in the law and what they can move forth. So know that I do not operate in commerce, that I operate solely 100% in the law in these respects. Still, if something were to happen to me, I have assured by the establishment of the instruments of trust that I've set up myself, that the Pope has been served, that the claims nor the trust that I've established will ever perish, ever. And remember, there's no statute of limitations. There's no time limit on claims of fraud and deceit in the common law or the law of equity. So these could sit for a long time and never be claimed, never be reimbursed. We could never be paid, because we have to wait for someone who can, go in and go, hey, here's a claim for how many amount of money, and pay me, and they go, we don't recognize you, because see, they control the banks. That's what they are, the banks. So we're waiting for the banking to change, but I definitely have claims and trusts that are there, and so in conclusion of all of this, which I know that there is tons of stuff in here, and I hope that people will appreciate this, and I know that it's very long, but there's so much information that I've given you in this that I would hope that if you're just a person of the law, that you understand that the biblical tenets and understand the distance between the common law and the man law, that the common law is the law of God and spirit and principalities, and that the man law is about commerce and things and bail and all that stuff, and the tithing. So no, I would say the last thing that I would say to you, for all you prophets or people that are going to bring writ, is that the Epistle of John is my favorite saying in the Bible. And again, I can't speak more highly about the first Epistle of John. In 3:13, he says, "Marvel not, my brethren, if the world does hate you." And I love that. I think that's the best thing ever said in the Bible. Do not marvel if the world hates you. Because from what I can see, if the four temples are of the temple bar, and we can bring a common law grand jury, we are well in Revelations and well in our way to the resurrection. Because as I said, in my opinion, the resurrection is not dead people coming out of the ground like zombies, which they always want us to believe. The resurrection is all of the enlightened people coming forth in spirit in the law and saying, I'm not dead. I have a spirit in this vessel, and I get to control where this flesh goes. I was given control of it by my God. So, to me, resurrection, I've been resurrected because I have told them I am not dead and I operate in the flesh, and that I operate in the law spiritually, so my soul is in so this is the temple of my soul. So I believe that I am resurrected, and I believe everybody that is trying to affect that they are not a thing is resurrecting themselves. So in my opinion, we are well into Revelations, and we are at the very end where the people are starting to be resurrected and the law is being affirmed. And in just a little bit, with just a little bit of effort, we might actually bring down the whore of Babylon. So peace be with all of you. I hope that, and all your relations. So peace be with you and all your relations. I hope that we all have enough. And namaste. And I hope that whatever wisdom that I have brought forth helps you particularly address the issues of how the common law in the Republic of America, the American Republic, is squarely founded within the tenets in the Bible, the law in the Bible. And that you don't have to be a Christian to understand these things and know these things. You just have to be one who believes that there's a higher law that we're all governed by. So again, namaste. Have a good evening if you watch this thing, or morning, and good night.